Hello students, today we will be discussing about agreement and contract, essentials of a valid contract and case laws related to valid contract, case laws related to agreement. Let us have a clear understanding about a statement. The statement is all contracts are agreements, but all agreements are not contracts. Let us discuss in a brief way. Yes, the above statement is correct. All contracts are agreements, but all agreements are not contracts. We can justify this statement by understanding the definition of contract and also by understanding the concept of agreement. So let us define a contract. A contract is an agreement between two or more parties which will be enforceable by law. As per section 2H of the Indian Contract Act, an agreement enforceable by law is a contract. Therefore, contract is an agreement whose objective is to establish a legal obligation, that is, a duty enforceable by law. So, what we can understand? It is very clear that the contract includes two elements: an agreement and legal obligation. So this is about the contract. So always try to understand that a contract is between two or more persons and it should be enforceable by law. Okay? So now let us go to agreement. Agreement means what? Offer plus acceptance. So here the section 2E defines agreement as every promise and every set of promises. Every promise and every set of promises forming the consideration for each other is an agreement. Promise, set of promises forming the consideration for each other is said to be an agreement. So it is very clear that promise is an agreement. The statement makes it clear that promise is an agreement. So when we define promise according to section 2B, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. A proposal, when accepted, becomes a promise. So in simple words, an agreement is made only when one party makes a proposal or an offer to the other party, and the other party accepts the proposal. That is, agreement is the sum of offer and acceptance. Is it clear? Agreement means Offer plus acceptance. Okay. Now let us discuss the features. Two features. How many persons are required for an agreement? What is a consensus addendum? So, coming to the persons, as one person cannot make an agreement with himself, there is a need of two or more than two persons to make an agreement. It is very clear. So, one person cannot make an agreement with himself. So, there is need of two or more than two persons to make an agreement. Next point. Consensus addendum means an agreement can be made only when both the parties accept the subject matter of the agreement in the same sense or in same time. This concept is said to be consensus addendum. So it is very much required. If consensus addendum is not present in an agreement, then the contract cannot be formed. So they have to have that same sense of feeling is very much required. If it is there, then only it is said to be an agreement. Next, we can have some examples also. For example, if the consumer asks 10 lakh rupees and if the vendor thinks that the consumer is asking 5 lakhs, then there is no consensus addendum. Hence, there is no contract. If the vendor asks the consumer, do you want 1 kg of sugar? And if the consumer says yes to it, then there will be consensus addendum and the agreement exists. So this is about the agreement and what are the features included in the agreement. Now coming to other concept which is called legal obligation. An agreement can become a contract only when it results into a legal obligation. This is very, very important. An agreement can become a contract only when it results into a legal obligation. Duty enforceable by law. The term obligation refers to as a legal tie-up which binds a particular person or persons in order to perform or not to perform a particular act or acts. If the agreement does not hold the capacity or capability to establish a duty enforceable by law, then it cannot form a contract. So it should be enforceable by law. Agreement enforceable by law is said to be contract. The term agreement is a wider term than a contract. All contracts are agreements, but all agreements are not contracts. The agreements which are social, moral, or religious in nature cannot become a contract as they cannot be enforced by the law. So let us have an example. P promises his friend Q that he will give a gift on his birthday. But due to lack of money, Q was not given a gift by P. Q cannot raise any claim for the gift from P, as it was not a legal agreement. Is it clear? So, you can't question P. Q can't question P. It cannot raise any claim as it is not a legal agreement. Law of contract is neither inclusive of the whole law of agreement nor the whole law of obligations. There exist various agreements which do not result in legal obligations, hence they are not contracts. In the same way, there are few obligations which are not generated or which are not created by an agreement. They are not contractual in nature but can be executed. It was noticed by Salman that the law of contract is not the whole law of agreements, nor it is the whole law of obligations. It is the law of those agreements which create obligations and those obligations which have their sources in agreements. In short, agreements that are enforceable by law are contracts, but those agreements which give rise to social obligations do not become contracts. It is necessary that agreements must give rise to legal obligations. Therefore, all contracts are agreements, but all agreements need not be contracts. Essentials of a valid contract. Again, let us define contract, and then we can in detail discuss about various elements of a valid contract. As you all know, a contract is an agreement between two or more parties which will be administered by law as per section 2H of the Indian Contract Act. An agreement enforceable by law is a contract. Hence, contract is an agreement whose objective is to establish a legal obligation. So, it is very clear from the definition, contract includes two elements, agreement and a legal obligation. Now, let us have a clear idea about the essential elements of a valid contract. An agreement, in order to become a contract, must have the following essential elements. First point, offer and acceptance. The contract, in order to become an agreement, must be made between two parties. One should make an offer and other should give its acceptance. The offer and acceptance must be lawful in nature, which means that they should fulfill the requirements of the contract act in relation thereto. So this is very, very important. So offer and acceptance, one should make an offer, other should accept it, and very important is it should be lawful in nature. So this is the first point which is very essential for a valid contract. Is it clear? Now let us go to the second point. Here the second point, it focuses on the purpose to establish legal relationship. The parties of an agreement should have an intention to establish a legal relationship between them. If such intention does not exist, then a contract cannot be formed. Very important. So, the parties of an agreement should have a legal relationship. If it does not exist, then a contract cannot be formed. Agreements of social or domestic type cannot be considered as contracts, as they will not fulfill the legal obligations. So, second point, it focuses on establishing legal relationship. Now, coming to the third point. Here, lawful consideration. An agreement can be enforceable by law when it has consideration. Consideration means what? Price paid by one party to the other, or it is a price paid by one party to the other for the promise made. An agreement is legally enforced only when both the parties provide something and receives something in return. The consideration may be an act, doing something, or forbearance, not doing something, or a promise to do or not to do something. It may be in the past, present, or future. It is not necessary that consideration must be in the form of cash or kind, but it is mandatory that it must be real and lawful. So therefore, an agreement is legally enforced only when both the parties provide something and receive something in return. Okay? So, lawful consideration. This is the third point. Coming to the fourth point. Capacity of parties, competency. This is very, very important. Capacity of parties and their competency. The parties to an agreement should be capable enough to enter into a valid contract, or else it would not be enforced by the court of law. A person is considered to be competent to a contract if he or she has the age of a major. Very, very important. So a major, sound mind, should not be declared as disqualified. So these three aspects are very important. So a person is considered to be competent when he is a major, he has a sound mind, and should not be declared as disqualified from contracting by any law which he or she has attempted to enter into. When we discuss about these competency, then what are the reasons for not being considered to be capable enough to enter into the contract? We have to know about that aspect also. So a minor is not competent. A lunatic person is not competent. An idiotic person is not competent. A drunken person is not competent. So if you find any person like this found with any of the above feature, then the agreement is not enforceable by law except in certain special cases. So next point is free consent. In order to make a valid contract, there should be free and genuine consent from the parties. This is very, very important. Free consent should be there. The party's consent is considered to be free if in case they agree upon the same thing in the same sense. The parties are considered to possess the same mind. They accept the subject matter of the contract in a similar sense at the same time. That is very important. So, you should have that understanding. The parties involved in the agreement, they should have a free consent is very important, and they have to agree upon the same thing with the same sense. That is very important. Free consent will be absent if the agreement is induced by coercion, undue influence, fraud, misrepresentation, mistake. If the agreement is violated because of any of the above factors, then the contract is voidable and it cannot be executed by the party responsible for coercion, undue influence, etc. The other party can either accept or reject the contract as per the rules of the Act. However, if the agreement is induced by mistake of both the parties, then it can be void. So that is about the free consent. So fifth point is also plays a very, very important role with respect to essentials of a valid contract. So 5 points we have discussed. So in these 5 points, first we have discussed about the offer and acceptance, purpose to establish legal relationship, lawful consideration, capacity of parties, competency, and free consent. So another 5 points are there. Let us discuss one by one. Lawful object. A contract is said to be valid only if the object of the agreement is lawful. Object should not be illegal, fraudulent, immoral, or oppressive to public policy. Should not cause any damage to a person or property. If the object is unlawful, then agreement would be void. So therefore, lawful object is the sixth point which we have to keep it in mind for valid contract. Next comes writing and registration. As per the Indian Contract Act, a contract can be either oral or in written form. So two ways, oral or written form. A few special circumstances it emphasizes on the point that an agreement, in order to be valid, should be in writing and it should be registered. As per Arbitration and Conciliation Act 1996, arbitration agreement should be in writing. So that we have to keep it in mind. It should be in writing. And if you discuss about the Transfer of Property Act of 1882, agreement of sale of immovable property should be in writing and registered before enforcing it legally. So therefore, writing and registration also plays a very, very important role for essentials of a valid contract. So next point, let us discuss about the certainty. According to section 29 of the Contract Act, agreements, the meaning of which is not certain or capable of being made certain or void, the agreement should be clear and certain in order to form a valid contract. Very, very important. So there should be clarity. It should be certain. Then only it is a valid contract. In case agreements are vague or uncertain, then it would be difficult to form the contract hence it cannot be executed. So certainty plays a very important role for a valid contract. Next, possibility of performance. Possibility of performance. Here, section 56, it states that an agreement to do an act impossible in itself is void. So, an impossible act, agreement to do an impossible act, it itself void. The contract can be valid only if it is capable of being performed, and if the act is impossible in itself, physically or legally, then the agreement cannot be enforced by law. So, please keep it in mind. Performance, possibility of performance is an essential element for a valid contract. If it is impossible to perform, then it becomes a void contract. It is not a valid contract. And finally, the last and important point here is not expressly declared void. Not expressly declared void. The agreement should not be declared directly void by the law enforced in a country. For instance, an agreement in restraint of marriage, an agreement in restraint of trade, an agreement by way of wages have been expressively declared as void under sections 26, 27 and 30 respectively. Case laws related to valid contract. Let us discuss some case laws such that whatever concepts which we have learned can be very much meaningful, and also we can understand those concepts with the help of these case laws. So let us have one case. For example, a young widow was forced to adopt a boy under the threat of preventing the body of her husband, who had just died, from being removed for cremation. Is the adoption valid? It is the case given. So here, this is you can explain it in a brief way. See, here in this case, we can they are asking about the adoption valid. We can say it, no, it is not valid. As you know, from the mentioned scenario, the adoption of the boy by the widow is not valid because she is not adopting the boy through her free will. This is very important. There is some forces there. She is being forced to adopt the boy. Thus, it would be considered as a form of coercion. Thus, adoption of the boy by the widow is invalid. So that's. Next, let us discuss another case. X agrees to sell his cow to Y, but unknown to both the parties, the cow had already died at the time of making of the contract. Is there a valid contract between them? Here also it is very clear. No, there is no valid contract between X and Y because they were unaware of the cow's death. When both the parties to the agreement are under a mistake, it is termed as bilateral mistake. According to section 20, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Coming to other case, here we have two persons, Ajay and Amar. Ajay invites Amar for lunch. Does it create a contract between them? It is also very clear. There will be no contract between Ajay and Amar. Why? It is a social agreement between them. It is not legal. A social agreement does not have any legal obligation, and therefore it does not create a contract. Another case. A has two cars, one blue and the other white. He wants to sell his blue car. B, who knows of only A's white car, offers to purchase A's white car for rupees 20,000. A accepts the offer, thinking that it is for his blue car. Is there a contract between A and B? Here also, no, there will be no contract. There is no contract between A and B because both the parties are at mistake regarding the matter of fact essential to an agreement. According to section 20, an agreement is considered as void when the parties to an agreement are under a mistake as to a matter of fact essential to the agreement. Another case. X offers to Y, I shall sell my car for 50,000 rupees to you if you give me your horse. Y agrees in writing to buy the car but refused to deliver the horse to X. Is there any binding contract? The contract between X and Y is not a binding contract. The essential element of a valid contract, that is a lawful consideration, is missing here. X is ready to sell his car, but Y refused to give his horse. No consideration is moving from Y to X. So there will be no contract. P applied for the principalship of a local college and the governing body passed a resolution appointing him. After the meeting, a member of the governing body privately informs him of the resolution. The resolution was subsequently rescinded. P claims damages. Will he succeed? P will not succeed and cannot claim damages from the governing body of a local college as the resolution of his appointment as a principal was not communicated to him by an authorized person. P did not receive any official information from the governing body regarding his appointment as a principal. Thus, there was no contract between P and the governing body of the local college. So, therefore, he can't claim any damages from the college, from the governing body. Next case. For reconstructing a ruined mosque, the Masjid committee requested for donation. A person promised to pay 500 rupees but did not keep up his promise. What is the validity of the case in the eyes of law? In the eyes of law, the case is invalid due to two reasons. One, donating an amount for the reconstruction of the ruined mosque comes under charity. In this type of case, parties usually do not have the intention to form a legal relationship. An intention to create legal relationship is one of the essential elements of a valid contract. Next, the second reason, consideration is missing in this case. No consideration, no contract. So two things play a very important role. So therefore, the contract here it is invalid. Now another case. Ajay being in need of money sells his new car for 1 lakh rupees purchased just 2 months back for a price of 5 lakhs. Afterwards, Ajay seeks to set aside the contract on the ground of inadequacy of consideration. Will he succeed? Ajay will not succeed and would not able to set aside the contract on the grounds of inadequacy of consideration, as he is willingly and knowingly agreed to sell his car for 1 lakh. According to Indian Contract Act 1872, consideration need not be adequate is one of the essentials of a valid consideration. So therefore, he has to sell his car. Next, A promises to pay B 1 lakh rupees. If he kills C, B kills C, A refuses to pay, can B recover the amount? B cannot recover the amount from A. Lawful object is one of the essential elements of a valid contract. In this case, A promises to pay B 1 lakh if he kills C. Killing C is illegal and immoral. So now let us discuss about the case laws related to agreement. There are only 2 cases. First case is A invites B to dinner at his house on Sunday. B hires a taxi and reaches A's house at the appointed time. But A fails to perform his promise. Can B recover any damages from A? No, B cannot recover any damages from A because the agreement between A and B is a social agreement and not a legal one. A social agreement does not have any legal obligation and therefore is not enforceable in the court of law. Second case. On the event of a private association, person openly declared that anybody who with his acceptance marries his daughter will be paid 25,000 rupees. After certain days, Mr. A married that person's daughter with his permission. Now Mr. A claims the amount of challenge from father-in-law whether Mr. A will succeed. So here in this case, a person makes a general offer saying that whoever marries his daughter with his acceptance will be paid 25,000 rupees. As per the terms and conditions of the offer, Mr. A married that person's daughter with his permission within a reasonable time. Thus, A can claim the amount of 25,000 rupees from his father-in-law and will succeed. Thank you.